Hello everyone, welcome to Laexcellence IAS Academy. We have discussed the places in news. We discussed ethnic conflict areas, wars, and also discussed the drying up lakes as well. But from this video, we'll discuss very important articles from the Indian Constitution. And also, we'll link it up, those articles, with the current affairs. Okay, let us start. The first article is Article 13. Article 13 simply says that any laws which are inconsistent with the fundamental rights shall be declared null and void. But what are the laws under Article 13? Laws under Article 13 includes the legislations which are enacted by the central government, state government, the ordinances by the president and governor, and also these includes bylaws, rules, regulations made by the executive, both the central as well as state. And also the laws under Article 13 includes customs and also the usages which has a force of law. If any of these laws violates the fundamental rights of the citizens, these shall be declared null and void. By whom? Supreme Court as well as High Court. Right? This called the judicial review. Is this judicial review is mentioned in the Constitution? No. The judicial review is not mentioned in the Constitution, but this power of the Supreme Court and High Court, who checks the validity of any particular law, which whether it violates the fundamental rights of the citizens or not. This is called the power of judicial review. Constitutional Amendment Acts, which are enacted by using Article 368, are these a law under Article 13? The first, in Shankari Prasad case, Supreme Court had said that Parliament can enact a law, it can take away any part of the Constitution, even including fundamental rights, by using Article 368. The Constitutional Amendment Acts are not part of the laws under Article 13. But in Goloknath case, Supreme Court had to overturn the earlier judgment, and it said that the fundamental rights are sacrosanct in nature, and Parliament simply cannot take away these fundamental rights by using Article 368 to amend the Constitution. Means the Constitutional Amendment Acts are law under the Article 13. But in Keshwanand Bharati case, when Parliament reacted to the Goloknath case in 1971 by enacting 24th Constitutional Amendment Act, right? This 24th Constitutional Amendment Act was challenged in the Supreme Court. In this particular case, Keshwanand Bharati case in 1973, Supreme Court simply overturned the earlier judgment again and said that Parliament has a power to take away any part of the fundamental rights. Parliament can take away any part of the Constitution by using Article 368. But simply, it cannot take away the basic structure, means it cannot touch the basic structure of the Constitution. But what is basic structure? Basic structure simply, there are fundamental features in the Constitution. These should not be taken away by the Parliament by amending the Constitution by using Article 368. This was again highlighted by the Minerva Mills case in 1981. Supreme Court in this particular Minerva Mills case, it said that judicial review itself is a basic structure. Means the judicial review is part of the basic structure. Supreme Court cannot take away the power of judicial from the judiciary. And this Article 13 also gives two concepts. One is doctrine of eclipse. This doctrine of eclipse simply says that any pre-constitutional laws which are violating the fundamental rights, means which are not consistent with the fundamental rights, these laws should not be declared null and void for permanently, but these laws can be suspended for a temporary period. This is called doctrine of eclipse. And again, this Article 13 also talks about doctrine of severability. What this doctrine of severability means? Only those clauses or those sections which are violating the fundamental rights of the citizens, those sections shall be declared null and void, not the whole law. Take for example, in 2021, Supreme Court struck down some of the portions of the 97th Constitutional Amendment Act, which talks about cooperative societies. Right? Supreme Court did not struck down whole 97th Constitutional Amendment Act, but struck down only some portions of the 97th Constitutional Amendment Act. This is called doctrine of severability. These two concepts are given by the Article 13. And next article we are going to discuss is Article 21, which deals with right to life as well as personal liberty. This article says that the life of the person shall not be taken away by the legislature or any executive authority unless there is a procedure established by law. Means, is there any procedure mentioned in any law by using that legislature or executive can take away anyone's life or also personal liberty, right? Means, in A.K. Gopalan case, Supreme Court had said that this Article 21 gives protection against executive arbitrariness, not the legislature. Means, the parliament or the state legislature can take away anyone's life by enacting any particular law. This is called procedure established by law. If there is any procedure, that procedure can be followed, someone's life or personal liberty can be taken away. But in Maneka Gandhi case, the Supreme Court took a broader view. It said that Article 21 not only includes the procedure established by law, but includes also due process of law. But what is due process of law? How it is different than a procedure established by law? Procedure established by law only seeks that there is a procedure that can be followed, whether it's maybe unfair or unreasonable. Due process deals with the fairness of the law and also reasonableness of law. Any law enacted by the legislature, whether it should be fair or reasonable, this deals, means due process deals with the fairness and reasonableness of any particular law. Means, Maneka Gandhi case also gives protection with respect to arbitrary legislative acts. Means, the legislature can't simply enact a law and take away any person's life or personal liberty. The law enacted by the parliament should be fair as well as reasonable. Take for example, in Hadia case, Supreme Court had said that right to choose a marriage partner is a fundamental right. Right to choose religion is a fundamental right under Article 21. But in Supriyo Chakravarti case in 2024, also called same-sex marriage case, same-sex marriage case. In this particular case, Supreme Court said that right to marry is not itself a fundamental right. You can choose partner. You have right to choose partner to marry someone. That is fundamental right under Article 21. But right to marry itself is not fundamental right. This is said by Supreme Court in 2024 in Supriyo Chakravarti or same-sex marriage case. Ranjit Singh, Supreme Court said that right to be free from the adverse effects of climate change is also fundamental right under Article 21. Now Article 21 after Maneka Gandhi case includes broad range of fundamental rights. Right to free from pollution is a fundamental right. And according to Mohini Jain case in 1992, Supreme Court had said that right to education is fundamental right under Article 21. Accordingly, Parliament enacted the 86th Constitutional Amendment Act in 2002 and inserted Article 21A, made right to education is fundamental right. Accordingly, under the age of 6 to 14 years of age, children are available or entitled to receive free education from the state. This is Article 21. So Article 21 includes procedure established by law as well as due process of law. By the way, due process law is a USA concept. Procedure established by is a Indian concept. Okay. Thank you. Hope you understand these two articles. We'll meet again in next video. Thank you.